मैं ऑडियंस का स्वागत करता हूं, जो 5:30 बजे 124 जूम की लिमिट पूरी हो गई है। आज ही हमने एक्सटेंड करवा ली, नहीं तो यूट्यूब पे जाना पड़ता। और आज हमारे साथ हमारे प्रोफेशन के लीजेंड राकेश गुप्ता जी, जो ITAT मेंबर रहे हैं, और ITAT में इनका रिकॉर्ड था कि 1 साल में इन्होंने मैक्सिमम हाईएस्ट डिस्पोजल का रिकॉर्ड है इनके नाम से, और लगभग सभी प्रोफेशनल डिग्रीज हैं राकेश जी के पास में। और फॉर्मल इंट्रोडक्शन के लिए मैं CA सुहानी मेहरवाल को इनवाइट करूंगा, वो राकेश जी को इंट्रोड्यूस करेंगे। वैसे इंट्रोडक्शन की कोई जरूरत नहीं है राकेश जी को। और सोमिल अग्रवाल जी राकेश जी के साथ पार्टनर हैं, यंग एंड डायनेमिक और एनर्जेटिक चार्टर्ड अकाउंटेंट हैं। और आज के टॉपिक को इनिशियल ब्रीफ सोमिल जी करेंगे। उसके बाद में जो कंट्रोवर्सीज हैं वो सभी राकेश जी के साथ हम डिस्कशन में लेंगे। तो अब मैं सुहानी मेहरवाल से रिक्वेस्ट करूंगा कि वो राकेश जी को और सोमिल अग्रवाल जी को इंट्रोड्यूस करें। उससे पहले मैं शॉर्ट में पिल्स के जो नेक्स्ट प्रोग्राम्स हैं उनके बारे में 30 सेकंड में आपको बताना चाह रहा हूं। 19 जनवरी को 15 CA CB रीड विद सेक्शन 195 के ऊपर पंकज शाह इंदौर वाले हैं, उनका सेशन है। उसके बाद में 22 जनवरी को संडे को 11 बजे हेल्थ के ऊपर प्रीति लोहिया चार्टर्ड अकाउंटेंट हैं, वो सेशन लेंगी। वो फिटनेस एंड न्यूट्रिशन एक्सपर्ट हैं। उसके बाद में 11, 12, 13 फरवरी को पिल्स की RRC है, आगरा, मथुरा, वृंदावन, भरतपुर, फतेहपुर सीकरी। और पिल्स की मेंबरशिप के लिए रिक्वेस्ट है कि पिल्स की मेंबरशिप लें। 1 ईयर, 2 ईयर, 3 ईयर और एडवाइजर्स कैटेगरी की मेंबरशिप है। अभी तक पिल्स के करीब 165 मेंबर हो चुके हैं। और आपसे रिक्वेस्ट है ताकि पिल्स साल में 1-2 फिजिकल प्रोग्राम और जो दूसरे चार्टर्ड अकाउंटेंट्स के लिए एंटरटेनमेंट के लिए थिएटर प्रोग्राम और इस तरह के प्रोग्राम आयोजित करती है, उसके लिए फंडिंग का अरेंजमेंट हो सके। और राकेश जी से एक रिक्वेस्ट और करूंगा कि वो अपने सेशन के बाद में राकेश जी का एक अलग पैशन है कि ये कविताएं भी लिखते हैं, तो मैं रिक्वेस्ट करूंगा कि ये जब तक सोमिल सेशन ले, जब तक कोई इस मौसम को देखते हुए कोई रोमांटिक सी कविता सुनाएं तो ज्यादा अच्छा है। बाकी इन्होंने इनके बेटे का आज ही UNO में कहीं पर नॉमिनेशन हुआ है, जिसके लिए वो प्राइज के लिए नॉमिनेट किया गया है, उसके लिए वोटिंग करें। और उस पर भी इन्होंने आज एक बहुत ही खूबसूरत कविता लिखी है। पर मैं रिक्वेस्ट करूंगा कि ऑडियंस के लिए एक रोमांटिक कविता सुनाएं बाद में, क्योंकि आज लोहड़ी का मौसम है और मकर संक्रांति और साउथ इंडिया में पोंगल वगैरह ये बहुत बड़ा फेस्टिवल है 13-14 जनवरी को। थैंक यू। मैं अब सुहानी को सौंप रहा हूं। सुहानी।
सोनिया म्यूट रखे हो। सोनिया म्यूट रखे हो।
Thank you, Poonia sir. And it's my honor to introduce our learned speakers, Dr. Rakesh Gupta ji, ex-ITAT member, and CS Somil Agrawal. सर आप सही कह रहे थे, डॉक्टर राकेश गुप्ता जी के लिए कोई इंट्रोडक्शन की जरूरत नहीं है, but anyway still he holds various degrees like FCA, FCS, AICWA, MBA, LLB, LLM, and PhD. Not only this, he is author of various books like on search, teaser, and assessment of search cases, law relating to black money, unsecured foreign income and assets. Not only this, he is member of International Association of Tax Judges, invited to address Chambers of Commerce and Industry on Finance Bill 2019 in Abu Dhabi and Bahrain, and so on. Now, I'd like to introduce our next speaker, C.S. Saumil Agarwal ji. C.S. Saumil Agarwal ji is a lawyer by profession and a qualified chartered accountant, cost management accountant, and a company secretary. He regularly appears before various benches of ITAT, High Court, Supreme Court of India. His article on corporate tax issues have been published on ITAT Online and Journal of various professional entities. Now, without wasting much more time, I would like to share the screen with our learned speakers.
Thank you, Madam, for wasting this much of time, because according to your own version, you do not want to waste further time. So in law, there is an inference that you were hitherto for wasting time. Anyway, thank you for the kind words spoken by you. Thank you, Poonia Sahab, for having asked us to be with all of you this evening to speak on a very hot topic, which has impacted to all professionals who are dealing with educational institutions, and they are impacted because of a recent decision from the Supreme Court, 3 judges bench decision from the Supreme Court in the case of New Nobel. So the schema of the today's deliberations would be like this. Saumil would speak for about 15-20 minutes about the salient points which are there in that decision, and thereafter then I'll pick up the thread from a point where he leaves it, and then we will dwell and discuss about the contentious issues arising out of the reading of this decision. I'll request Saumil, first of all, to give a brief account of the salient points which are decided by Honorable Supreme Court in New Nobel's decision. I'd request Saumil to use a mixed language, and to which I'll call it that he should speak in English, Hindi and English. Over to Saumil.
Thank you, sir. My Guru Rakesh sir, respected Punia sir, seniors in the profession, and my very dear friends. New Nobel decision by the Honorable Supreme Court. The issue before the Honorable Supreme Court was with respect to the registration under Section 1023C, subclause 6. Now, this provision provides that any educational institution or university existing solely for educational purposes and not for purposes of profit, the income of such institution would be exempt. The underlying decision was judgment of Honorable Andhra Pradesh High Court. The Honorable High Court held that in the memorandum of the SSC, there were objects other than education, and therefore they were not existing solely for education. The second aspect that was there in that decision was that under the Andhra Pradesh Charities Act, the detailed name of this act is Andhra Pradesh Charitable and Hindu Religious Institution and Endowments Act 1987, which I'll refer as AP Charities Act. So the institution did not get itself registered in this act. And the issue arose whether the requirement of compliance of any other law is mandatory for the purpose of exemption under Section 1023C6. Regarding the first issue, rather, usse pehle sir, 1023(6) education, and important words of this language, solely for education purposes. Now, education is judgment mein, it has been again reiterated, I would say, Lok Shiksha trust judgment, and what education is has been defined. Rather it has been reiterated. Education, the concept derived in Lok Shikshan Trust in respect of 215 has been reiterated. The provision is, or the interpretation is, that formal education, teachers and taught, the development of younger generation, skills, knowledge, character by way of formal schooling. Sir, learning to magazines, newspapers, even for that matter, travel is also a part of learning. But for the purpose of the provisions and the sense in which these provisions have used education has been interpreted, and it has been reiterated that formal schooling where there are teachers and taught is what is education. तो सर पहला इशू सोनली फॉर एजुकेशन का इंटरप्रिटेशन. दूसरा इशू जो इंसिडेंटल सरप्लस की बात आती थी कि साहब प्रॉफिट है तो ये एजुकेशन नहीं कर रहे हैं, वो भी एग्जामिन किया गया. एंड तीसरा कि किसी और लॉ की रिक्वायरमेंट, लोकल लॉज, लोकल अथॉरिटीज, स्टैट्यूटरी अथॉरिटीज, स्टेट लॉज के अंडर कोई रिक्वायरमेंट है, अगर वो कंप्लाई नहीं की गई है तो क्या एग्जेम्पशन मिलेगी. solely the Honorable Supreme Court has held that objects should only be in relation to education. So much so, अगर आपके ऑब्जेक्ट्स में और एक्टिविटीज हैं which are not linked to education and the institution is not pursuing them, वो सिर्फ ऑब्जेक्ट्स में है, एक्टिविटी एक्चुअली नहीं की जा रही है, then also 1023(6) will not be available. So objects cannot have anything other than education in them. That is the first proposition which has been laid down in this judgment. That objects of the trust or institution which wants exemption under 1023(c)(6) can only have objects in link with education only. Irrespective if they carry out or not, they cannot have any other object other than education. Even सूरत आर्ट सिल्क, अमेरिकन होटल्स, क्वीन एजुकेशंस, वो जजमेंट्स को रेफर किया गया. एंड 215 के पर्पस से जो पहले लॉ सेट हुआ था कि साहब इंसिडेंटल सरप्लस हो जाता है, प्रॉफिट हो जाता है, तो एग्जेम्पशन नहीं डिनाई होगी. डोमिनेंट ऑब्जेक्ट होना चाहिए एजुकेशन. तो उस कंटेक्स्ट में वो 215 और वो जो प्रोविजंस थे, उस कंटेक्स्ट को लेते हुए सुप्रीम कोर्ट ने कहा नहीं, आपके ऑब्जेक्ट्स में भी एजुकेशन के अलावा कुछ नहीं हो सकता. 1023(6) की लैंग्वेज solely for educational purpose. And this I am highlighting for the reason कि इस जजमेंट में अपने आप में in para 51 the court has acknowledged a distinction between 215 provisions of 215 and the language of solely for education and not for purposes of profit in the provision of 1023(c)(6). So, to my mind, this interpretation, limited education objects in the memorandum are in respect of institutions which are claiming exemption under 1023(c)(6), and for the reason that this provision specifically has two important phrases: solely for education and not for purposes of profit. So, very narrow compass has been read into this provision. Then sir, अब एजुकेशन इंस्टीट्यूशंस हैं, हॉस्टल्स भी होते हैं, जो एनसीईआरटी और इंस्टीट्यूशन से रजिस्ट्रेशन मिलता है, वहां कंडीशंस भी होती हैं, हॉस्टल्स भी होने चाहिए आपके मिनिमम इतने. देन ट्रांसपोर्ट, स्टूडेंट्स के ट्रांसपोर्टेशन के लिए बसेस भी होती हैं, टेक्स्ट बुक्स दी जाती हैं, स्टेशनरी. सो द क्वेश्चन अरोज कि ये जो एक्टिविटीज हैं, दे आर इंसिडेंटल और इंटीग्रल. Sir, I remember we have argued number of decisions. Jahan earlier in respect of 11.4a, where department used to argue कि साहब ये तो incidental हैं, इनकी अलग book maintain नहीं करी गई हैं, इसलिए exemption नहीं मिलेगी. So decisions were laid down कि these activities, hostel, transport, textbooks and all, these are integral part of the activity of education. And therefore 11.4 तो apply करेगा ही नहीं. They are in the main activity of education. लेकिन in this decision, while examining the 7th proviso of 1023C, which is paramateria with 11.4a, की activities जो incidental हैं वो permit की जाएंगी, exemption मिलेगी. अब वो incidental क्या है, उनका scope क्या है, their lordships have given by way of examples. और वो examples यही हैं: hostel, flying buses for transportation of students. तो जो चीज हम पहले इंटीग्रल मान के चल रहे थे उनको इंसिडेंटल कर दिया. They are now incidental activities. So separate books have to be maintained for such activities. And if the requirement of 7th proviso 1023C of separate books is duly complied with, exemption is available. लेकिन अगेन वो जो इंसिडेंटल का जो स्कोप है वो नैरो कर दिया गया. इंटीग्रल इंसिडेंटल में आ चुका है, और जो हम पहले समझते थे इंसिडेंटल हैं, से फॉर एग्जांपल एजुकेशनल इंस्टीट्यूशन है, उन्होंने अपना हॉल, सेमिनार हॉल दूसरे एजुकेशनल इंस्टीट्यूट को अपने स्टूडेंट्स के लिए, उनके स्टूडेंट्स के लिए सिर्फ वर्कशॉप कंडक्ट करने के लिए दे दिया. इन अ कैटेगोरिकल एग्जांपल टेकन इन दिस जजमेंट, द लॉर्डशिप हैव हेल्ड कि ये एजुकेशनल एक्टिविटी का पार्ट नहीं बनेगा, ये आपकी अदर इनकम है. अगर आपके अपने स्टूडेंट्स के लिए आप वर्कशॉप करते हैं, ठीक है, दैट इज इंसिडेंटल एक्टिविटी, बट आप किसी और को नहीं दे सकते.
आपकी फोटो नहीं आ रही.
Please continue.
Yes sir, I'm continuing. Yes, so even so much so, hostels, मान लीजिए कोई कॉर्पोरेट इवेंट या कोई फैसिलिटी है, हम दे देते हैं और हॉस्टल यूज करते हैं अगर, या कोई 3-1 महीने का सर्टिफिकेशन कोर्स करते हैं किसी और कॉर्पोरेट एंटिटी, या उनके लिए उनके लोग आके आपके हॉस्टल में रहते हैं, दैट एक्टिविटी इज नॉट इंसिडेंटल ऑल्सो, वो अदर इनकम में जाएगा. तो एक्टिविटी विच इज डायरेक्टली inextricably linked with the primary activity of education conducted by the institution for its own students, and it can include incidental activities like hostel, transportation and everything for their own students, that is covered in incidental, and separate books have to be maintained. That is the second proposition laid down in this judgment. Now linked with this, sir, although as I started initially, judgment wasn't linked with 1023C6, the issue was with respect to 1023C6, but जजमेंट में स्पेसिफिक मेंशन है 11.4a का, जो कि पैरामटीरियल सिमिलर कॉन्सेप्ट 11-12 के रिजीम में है कि इंसिडेंटल एक्टिविटीज में आपको सेपरेट बुक्स मेंटेन करनी पड़ेगी. तो टू माय माइंड जो प्रोपोजिशन ले डाउन किया गया है इन रिस्पेक्ट ऑफ इंसिडेंटल एक्टिविटीज, in view of the specific mention of that provision in the judgment, even in the conclusion, specific observation by the honorable court, वहां भी apply करेगा. And they have further said कि similar activities जो और provisions में है 1023C6 में, C में, hospitals हो गए, medical institutions हो गए, उनके में भी similar concept derive किए जाएंगे. That also is the observation by the honorable court. Sir, next aspect, compliance of any other law. Is in the present case, as I said earlier, AP Charities Act का जो requirement था registration का, वो comply नहीं किया गया. The court held, you know, if the laws, other laws, the requirements, the compliances under the other laws have not been complied with, then registration cannot be granted under the Income Tax Act 1023C6. तो बाकी लॉज की कंप्लायंस मैंडेटरी है. The next aspect, sir, scope of inquiry. Judicial precedents have been laid down कि साहब at the time of registration आपको objects देखने हैं. अकाउंट्स में या क्या इनकम है, एक्टिविटी है, नहीं है, आपको ऑब्जेक्ट्स देखने हैं. ऑब्जेक्ट्स अगर एजुकेशन है, रजिस्ट्रेशन मिल जाएगा. The Honorable Court have held that this assumption or this phenomena can work in respect of newly set up organizations. Yes, they may not have activity, but restricting the powers of the approving authority will not be correct. क्योंकि existing institutions भी apply कर सकते हैं, and therefore accounting records, books of accounts, इनका examination भी approving authority के powers के अंदर है कि वो examine कर सकते हैं to see whether the activities are genuine and whether the objects are only for education or not. Although to my mind, in view of the latest amendments, the paradigm shift in the overall concept of registration in 1023C6 कि जहां सर पहले आपका प्रोविजनल होता है, बाद में मैंडेटरी परमानेंट रजिस्ट्रेशन मिलता है. तो पहले तो ये आर्ग्यूमेंट होता था कि साहब अभी तो नया नया काम शुरू, रजिस्ट्रेशन किया ही है, अप्लाई कर रहे हैं, एक्टिविटी कैरी आउट की नहीं है, बुक्स कहां से लाएंगे. लेकिन अब तो 2-3 साल का पीरियड होता है जिसमें कि प्रोविजनल उसमें एक्टिविटीज कैरी आउट हो रही हैं. तो दैट रिकॉर्ड कैन बी summoned by the approving authority to examine whether the activities are for the purpose of education only or not, and whether they are not for the purpose of profit or not. तो approving authority की powers पे कोई fetters हो, ये कोर्ट ने disapprove कर दिया है. उन्होंने कहा है कि he has all the powers to call for the record and examine, but उनका जो examination होगा, not much weightage has to be given to mere incidental surplus. अगर कोई प्रॉफिट हो भी जाता है 1-2 साल में, तो बहुत ज्यादा वेटेज उस टाइम पे नहीं दी जाए उसको. प्राइमरीली एक्टिविटी, नेचर ऑफ इनकम अर्न्ड, एजुकेशन की एक्टिविटी को एग्जामिन किया जाए. आउट ऑफ प्रोपोर्शन वेटेज ओनली टू द प्रॉफिट बीइंग जनरेटेड शुड नॉट बी गिवन. ये भी उन्होंने साथ में कहा है. So primarily, the approving authority should go into objects, the genuineness of activities, and they may look on the books of accounts from the perspective that yes, the institution is existing solely for education only and not for the purpose of profit. And to derive that, they may call for books of accounts. That's the powers they have. One cannot be heard saying that at the outright, they cannot call for the record. That is the next aspect which I wanted to discuss. So, sir, first and foremost, before I come to the aspect from when this judgment is applicable or how it can be applicable, how this law is applicable, summing up the aspects, number one, the objects can solely be for education. Objects cannot have any other object apart from education. Incidental activities, the scope is activities जो कि आपकी प्राइमरी एक्टिविटी एजुकेशन से लिंक्ड है, ट्रांसपोर्टेशन, हॉस्टल, मेस, यूनिफॉर्म, और वो भी अपने स्टूडेंट्स के लिए. That is the incidental activity which has been covered, and separate books of accounts have to be maintained for the purpose of claiming exemption. Then जो क्वींस एजुकेशन, अमेरिकन होटल्स का जो कॉन्सेप्ट, डोमिनेंट पर्पस, that has been disapproved by the honorable court. Solely for education means only education in the objects clause. Approving authority, he can call for records, and with the guidelines given by the court, not much weightage should be given to the aspect of profit. And then the compliance, requirement of compliance of any other law. any Charities Act or any other law which is applicable on the institution, that must be adhered to, that must be complied with in order to claim exemption under 1023C6. Sir, profit के respect में merely because profit 1 या 2 साल में generate हो जाता है, that itself will not render or that will not disable the exemption being claimed under 1023C6. The registration will not be cancelled or rejected for that purpose. लेकिन अगर बैक टू बैक सरप्लस हो रहा है और एक्टिविटी या बुक्स ऑफ अकाउंट से निकलता है कि नहीं, ये तो प्रॉफिट का एक मेन एलिमेंट है, प्रॉफिट जनरेशन भी एक फोकस हो रहा है, देन दैट कैन बी अ प्रॉब्लम फॉर गेटिंग रजिस्ट्रेशन अंडर 1023C6. अब सर, what about the pending matters? What about the application of this judgment? From when will this law apply? So I'll read 3 lines from the judgment which are very important. This court is further of the opinion that since the present judgment has departed from the previous rulings regarding the meaning of the term solely, in order to avoid disruption and to give time to institutions likely to be affected to make appropriate changes and adjustments, it would be in larger interest of society that present judgment operates hereafter. That is prospective. As a result, it is hereby directed that the law declared in the present judgment shall operate prospectively. अब सर, प्रोस्पेक्टिव तो ऑनरेबल कोर्ट हैज सेड कि हाँ, ये जजमेंट जो हम डिक्लेयर कर रहे हैं प्रोस्पेक्टिव है, बट उसी जजमेंट में जो पेंडिंग अपील थी उसको रिवर्स भी कर दिया. तो अब क्वेश्चन ये आएगा कि साहब, जो पेंडिंग अपील्स हैं उन पे ये इफेक्ट करेगा, लेकिन जो मैटर्स खत्म हो चुके हैं, क्या उसको ये रीओपन कर सकते हैं जजमेंट की बेस पे? दैट आई डोंट थिंक सो वुड बी पॉसिबल, क्योंकि जजमेंट लॉ डिक्लेयर्ड इज प्रोस्पेक्टिव. So with this question and with this aspect, that is judgment की applicability, prospective, and how prospective this prospectivity would have to be read, understood, is the question I put forward to Rakesh Gupta sir. And with this, I hand over to Rakesh sir to take it forward.
Thank you, Somil.
For the patient hearing. Thank you, sir.
Thank you, Somil, for preparing the pitch for me. Now, as Somil has explained the broad contours of this decision, and this decision which was given specifically in the context of approval of educational institutions under section 10 clause 23C and subclause Roman small 6. Therefore, the question which comes, whether the ratio of this decision would apply in respect of educational institutions which are covered under section 1023C 3IAD, and those educational institutions, trusts and societies which are registered or which seek registration under section 12AB or were registered under section 12AA. Now, in order to answer that question, now we have to read the specific language which the legislature has used in section 1023C6. And when we read that language, then we find that that language is identical to the language used in clause 3IAD. In 3IAD institutions, having the gross receipts lesser than the amount of 5 crores as prescribed in the rule, now in the statute itself, rest of 1023C, 3IAD and 6 is identical. In 6, if the receipts are more, then you will have to approach to the prescribed authority to seek approval. Therefore, the ratio of this decision insofar as it seeks to explain and lays down as to what is the meaning of the word solely and not for profit, because these two terms, which are very important and which have come to be interpreted by their lordships this decision in New Nobles Educational Society, now they are there in 3I AD also. So there is perfect applicability of 1023C6 decision of New Noble Educational Society to those educational institutions which are covered under section 1023C 3I AD, in order to see whether that educational institution exists solely for education and that educational institution is not for the profit. But since the registration under section 12 AB now is not so worded as is worded under section 1023C6, therefore, in my respectful submission, the ratio of this decision in its entirety may not be applicable in respect of those educational institutions, trusts and societies which are registered under section 12AA, now under section 12AB, or wants to seek approval under section 12AB. But I am saying the whole of the decision may not be applicable, but then certain aspects of the matter, now which has been so referred in this decision, referring to section 11, say subsection 4 capital A, as Somil has spoken about the incidental to the educational activity. I mean, to that extent that may be applicable. But primarily the approval under section 1023C6 and approval under section 12AB, I mean, since they stand on a different pedestals in view of the different phraseology which the legislature has used, therefore, the ratio of these decisions may not apply completely on the trusts and institutions seeking registration under section 12AB. Not for profit was an expression which we always used to understand. That even if there are surpluses, even if there are, say, profits, but those profits are incapable of being withdrawn or distributed amongst the trustees or the managers or for the private benefit, and those surpluses are capable of being used only for the purpose of educational institutions, trust and society, then it cannot be said to be for profit. Now that interpretation has received a very big hit by this decision, because the not for profit has come to be interpreted by their lordships in this New Noble Educational Society's decision that incidental surplus is one thing which is permissible, but then if the object smacks of earning profit with a profit motive, then you cannot be said to be existing not for profit. Therefore, this distinction, now there cannot be only one factor which would determine or decide whether it is incidental or whether it is with profit motive. It is the entire gamut of operations, your activities, including your objects, that will show, and the activities, of course, pursued by you, that will demonstrate, that will show, that will establish, that will prove whether you are or you can be said to be existing not for profit, or you can be said to be existing for profit. The next question now which comes for consideration as a result of this decision is, when the lordships interpreted the expressions that you should exist solely for education, so the lordships have discarded the earlier theories propounded in Queen's Educational Society or in American lodgings decision, and have laid down that exclusive, solely means exclusively. Solely does not mean predominantly. And therefore, while driving home the point, the lordships have further said, now whether you exist solely for education will have to be decided having regard to your objects. So if there are objects which are other than education or which are not in relation to the incidences of education, then you cannot be said to be existing solely for educational. There must be objects relating to education, or those objects which can be said to be incidental to the education. Even if your object clause contain only those objects which are incidental to the education, but objects relating to educations are missing, then also the lordships have said you cannot be said to be existing solely for education. Incidental to educations can very well be there in your object clause, provided first of all there is an object of education. Only then the incidental objects to educations can be there. But then incidental objects or objects relating to the incidence of educations alone, if alone they are the objects, then you cannot be said to be existing solely for education. Even if you may not be carrying out, there are several objects in your object clause. Some of them are not relating to education. Some of them are not relating to the incidence of education. Even if you may not be pursuing those objects other than education, yet the very existence of such objects in your object clause, according to the interpretations placed by the lordships in this decision, lay down that in that situation you cannot be said to be existing solely for education. So those educational trusts and institutions which seek approval under section 1023C, they must ensure, at least henceforth, and that is why the lordships have given some breathing space to educational trusts and institutions to adjust themselves, because the lordships were conscious and were aware that they are inventing a new jurisprudence which was hitherto not there, and therefore they should give some breathing space to the existing educational trusts and institutions to be in line with the new propounded jurisprudence. Therefore, those educational trusts and institutions which have sought approval under section 1023C or which are otherwise covered under section 1023C 3IAD must ensure, before they are called upon to exist solely for education, that their object clause must comprise solely, exclusively only those objects which deal with education or which can be said to be the incidental to education. And wherever their objects clause are wanting on this point, all such educational institutions and trusts will have to amend their object clause to remove such objects which are not educational or which cannot be said to be incidental to education. Therefore, this decision would apply. Therefore, in the light of this decision, the object clause of such educational trusts and institutions which comprise objects other than education will have to be taken out. If they are not taken out, they may be in problem for the purpose of section 1023C6. And a little while ago, as I said, that if your educational trust institution, society which is registered under section 12 AB, then your object clause may be having other objects also relating, and of course those objects also must be relating to the charitable objects, because the charitable purpose has been defined under section 2 clause 15, and it contains as many as 7 specific activities or purposes which are charitable purpose. And then the last one, the residuary general public utility purpose. But 1023C6, after this decision, as having been interpreted in very narrow compass, as Somil has said very rightly, therefore not much elbow room now is there. The next issue, now this, what is this incidental? Now suppose there is a trust or institution now which says that they will finance the education by extending free scholarships or by extending loans to the needy students, or they will publish books, and those books which are used in the course curriculum. These objects are incidental to the education, but they cannot be said to be education in itself. These objects can exist, as I explained a little while ago. These incidental objects can exist along with the main objects of education. But if these incidental objects are there and main objects of education is not there, then such charitable institutions cannot be said to be existing solely for education purpose. But not for profit term, which is there under section 1023C and which has come to be interpreted by their lordships in this decision. Now it says that incidental surplus is all right, but then there should not be any profit motive. And in order to drive these interpretations, their lordships have gone on the 7th proviso to section 1023C to say that wherever legislature wanted such charitable institutions to earn profit, they have permitted them to carry on business. But even with a rider and fetter and limitation or restriction that such activities should be incidental to the main object. You can carry on an activity in the nature of business provided it is incidental to the main activity of your education. As Somil has said, there used to be a point of time when we used to argue that maintaining a hostel for your own student is not even an incident to the business, is not even incident to the education. That is part of education. Because the rendition of education, the imparting of education to the students in the institution has been approved by National Council of Technical Research by making it mandatory for you to have hostel. Only then you will be permitted to impart education. Therefore, even the maintenance of hostel for your own student was intrinsic to the education. But now after this decision, since the Supreme Court has mentioned, categorized, explained that maintenance of hostel is incidental to the education and is in the nature of business which is permissible as per the 7th proviso to section 1023C. And if there are profits while carrying out that kind of a business which is incidental to the main purpose, then that is permissible under the law, provided you maintain separate books of account. And while dealing with 1023C, Supreme Court, I do not know how was it persuaded to refer subsection 4A of section 11. Supreme Court found that the language of subsection 4A of section 11 is in perimeteria with the language of 7th proviso to section 1023C. And thereby, now even for those charitable trusts and institutions which are registered under section 12AB, now since subsection 4 capital of section 11 has come to be interpreted, has come to be referred by Supreme Court, maybe by way of an obitur dicta, but then obitur dicta coming from the highest court of the land has got the binding effect. So, not for profit has been interpreted in a very unique way, which was never understood in that sense so far in the past. But then this decision, which has come from the Supreme Court, consisting of 3 honorable judges, therefore, I mean the ratio laid down by this, unless of course it is set at naught or it is interpreted by a subsequent bench, now this will hold the field. Now, one question which Somil has also referred and which has been detailed in a very elaborate manner is that what is the scope of inquiry by the competent authority while granting approval? Because so far the jurisprudence which we were taught to us and which we used to understand was that the jurisdiction of the competent authority at the time of granting approval is only to see whether the objects are educational or not, and whether the activities are being carried out in accordance with the objects of the trust or the society. And whenever these competent authorities used to traverse through the accounts and then used to say about the profit element or the surplus element, then such kind of an overreach by these authorities used to be repelled by the higher appellate for us. But now Honorable Supreme Court has laid down that, as Somil has said, that no fetters can be read into the power of the competent prescribed authority while granting approval. So, according to these decisions, the competent approving authorities can go into your books of accounts, because even going into the books of account is necessary for that competent authorities to be satisfied that the activities are being carried out in accordance with the objects, and in order to see whether the activities are being undertaken with a profit motive or not. The second facet which can be examined now after this decision by the competent authorities as to whether the funds of that educational institutions and trusts which are required to be invested in the prescribed and permissible modes of investment as listed under subsection 5 section 11, whether are being invested in that manner or not. So competent authority is entitled to look into your objects, is entitled to look into this fact whether the activities are being carried out in accordance with objects of the charitable objects or not, entitled to go into your books of accounts, entitled to see the investment of funds. And then one more point now which has been now enacted in the statute, but which has been read into this decision as if it was always there, that compliance of any other law which are material for the purpose of achieving its objects, now even that also can be gone into by the approving authority. Now you may be aware that section 1023C, or for that matter section 12AB, now have been rewritten. and under the new provisions of approval or registrations, now even this power has been given to the approving authority or the registering authority, ki whether this society or the trust seeking registration now is complying with any other law which is material for the purpose of achieving this object. Because if you remember, in certain searches carried out on the educational institutions, it was found that huge amount of capitation money has been taken for the admissions in medical colleges or in engineering colleges. Now, they could not have taken that capitation money because there are specific enactments made by the different state legislatures that they cannot accept the capitation money. But when the approving authorities cancel their registration on this ground that they have accepted the capitation money, then the argument which found favor from the court was that this power of cancellation is very specific power. It can be cancelled only on the prescribed grounds, and flouting of some law now is not one of the grounds on the basis of which the registrations or the approval can be cancelled. The legislature became then wiser, and therefore last 2-3 years when wholesale amendments were made, now this was specifically inserted that even compliance of any other law which is material for the purpose of achieving its objects is also a necessary ingredient. But then this was added about 2-3 years back only. Now the decision of New Noble Society now definitely is a decision in respect of the law which was much anterior to this amended law. But Honorable Supreme Court in this decision has read even this requirement of seeing compliance of any other law which is material for the purpose of achieving its objects as if it was there, because the lordships have said, approving the decision of Andhra Pradesh High Court, that if a state legislature has enacted some law monitoring public charitable institutions, then even the compliance of that law, if registration is required under that state law, you must get yourself registered, because state authorities have also right to monitor your public charitable functions. So this is a very important proposition which has been laid down by their lordships in this decision. Now regarding the prospective application of this decision. Now there is an established jurisprudence insofar as the effect of the Supreme Court's decisions are concerned. And that established jurisprudence is that Supreme Court does not make law. Laws are made by the Parliament. Making or the legislating law is the exclusive preserve and prerogative of the Parliament. Courts interpret the law. So the established jurisprudence so far has been that Supreme Court does not make law. It merely interprets the law as if this law which is now interpreted by the court was always like this. So had Supreme Court in this decision in New Noble Educational Society not said that this decision will be applicable prospectively, then as per the established jurisprudence, the decision given by Supreme Court by interpreting the scope of section 1023C6 would have been read as if the law was always like this. But since Supreme Court has said that this decision is applicable prospectively, therefore this edict, this mandate, this binding declaration of the position of law that it will come into effect prospectively now cannot be ignored. Somila said that the decision itself has dismissed the appeals which were involved. But of course, yes, those cases which were there involved as per the decision of Honorable Supreme Court in this civil appeal, of course, were to be impacted by the decision given. Now, but for the rest of the matters which will come up according to my interpretations, though somebody can dispute. Now, even the pending appeals at various forums involving these very issues now will have to be decided in the light of the law which was hitherto available. So the new interpretations of not for profit, the new interpretation of existing solely, the new interpretation of the scope of inquiry, the new interpretation of seeing the compliance of any other law, in respect of all other appeals which are pending before various forums. Because of this specific mandate by Supreme Court that its decision will come into effect prospectively, will be decided as per the old interpretations placed by Supreme Court. So Queen's Educational Society and American Boarding and Lodging Association's decisions, which have been overruled by this 3 judges bench decision in New Noble, now will still hold the field, in my respectful submission, when it comes to the interpretations in respect of the pending appeal. Otherwise, what was the point of saying it will be applicable prospectively? And Supreme Court has specifically said that we are giving time educational trust and societies to adjust itself. So if object laws are having some other objects which are not relating to education, so they have been given some elbow room to adjust, amend their objects, adjust themselves. So till the time such adjustments or some alterations of the amendments are made, the position of law that you have to see the dominant object as laid down in Queen's Educational Society or American Boarding and Lodging or Aditnath, that has to be made applicable. That is what my respectful interpretation is. Of course, no 147 can be made based upon this interpretation. No rectification proceedings can be taken. When my respectful interpretations, even in respect of the pending appeal, is this, that this decision is not applicable, then what to say of applying this decision in respect or by invoking section 147 or by invoking section 154 in respect of the concluded matters? So according to me, this will apply henceforth. So any approval sought by educational institutions on or after 19th October 2022, when this decision was rendered, now will have to be seen in the light of the law laid down by their lordships in New Noble. Otherwise, in my respectful submissions, the pending appeals now will have to be seen on the touchstone of the law which was existing hitherto as interpreted by the court. Now, one more question which has been, Poonia Saab now is known for his very sharp questions. I have had occasion to meet him for the first time in 2021 in Kevadia. And on second occasion, I met in December when I came to Jaipur to attend RTCA program. But then since I had been seeing him in the social media, the kind of questions and the kind of devotion and commitment he has got, I have got all kudos and appreciation for him. So this question, now which was also sent by him, was that now can some charitable trust and institutions say that we do not need your registration, and we would pay tax, as was done by the Tata Trust. The department said, no, how can you disclaim it when there is no such power to disclaim it? And in case you disclaim it, now whether the provisions of section 115 TD, which is very tedious, harsh and arbitrary provisions, now can be made applicable. Now, first of all, if some charitable trust and institution wants to offer the surplus to tax, now there should not be any fetter or restrictions on such kind of voluntary offer as to the taxability. Exemption, to seek relief, to seek immunity, to seek rebate, to seek deduction, to seek exemption is permissible only when the law permits. But then if somebody does not want to avail the benefit of a particular provision, it cannot be thrust. So if somebody wants to say that there are surplus at my end, I want to pay tax, then department cannot be heard saying, no, we will not allow you. But then the question comes, now whether by offering the tax in this manner, now are you infringing or are you leading yourself to the applicability of section 115 TD? And that section is a very dangerous section. Now that section says that if you lead yourself to be in a position which is incapable of being approved or registered, or when registration or approval given to you has been cancelled, then you have to pay tax on the accredited income. Accredited income, the difference between the market value of the assets and the cost at which these assets were acquired by these charitable trusts and institutions. You'll have to pay tax at 30%. But when I was reading section 115 TD, then I found that 115 TD can be invoked only in the prescribed situations, and those prescribed situations are given in section 115 TD. And I will take help of the book, the Act, because that is a very interesting situation. I mean, it is a lapse, I do not know, but it says that 115 TD is applicable when you have converted yourself into any form which is not eligible for grant of registration under section 12AB. But then what is the meaning that you have converted yourself into any form which is not eligible for grant of registration? Now, three situations have been envisaged under subsection 3 of section 115 TD. We will come to that. Second is, when you are merged with any entity other than an entity which is a trust or institution having objects similar to it and registered under section 12AB, or failed to transfer upon dissolution. So clause A is important, on which I wanted to highlight. Now clause A is when you have converted into a form which is not eligible for grant, and that has been given a specific meaning. Subsection 3 says, when the registration or approval granted to you under section 12A, 12AB or under section 1023C has been cancelled. Now, if I do not want to avail the benefit of exemption on my own, my registration has not been cancelled. Since my registration has not been cancelled, therefore this disability will not apply to me. Second is that if I have adopted or undertaken modification of my objects which do not conform to the conditions of registration and it has not applied for fresh registration, this is also not applicable on me. By not availing the exemption cannot be equated with a situation which is so envisaged under the law. Now it says that if you have altered your objects clause and you have not applied for registration. So I have neither altered my objects and therefore there was and my registration is there. So I am not hit by this. And third is when you have filed application for fresh registration or you have gone in for approval and said application has been rejected. So it has not been rejected. Rather, one situation which has not even been envisaged by this disability is that even if after the expiry of the registration, my period is over, I do not go in for fresh registration. Then also section 115 TD is not applicable on me. This is very important. Now, say because registrations now are granted for a particular period, that period comes to an end. I do not go in for the re-registration. Section 115 TD is not applicable. Now, Commissioner cannot invoke section 115 TD on the ground that you have not made fresh application for registration. Therefore, I will apply 115 TD. Whatever assets are accredited to you, you pay. No, he cannot be heard saying. Because 115 TD is a punishing provision and therefore its scope will have to be seen strictly having regard to the language which the legislature has used. Therefore, these two situations, according to my respectful submissions, are not covered under section 115 TD. The one when SSE, though registered, though is entitled to claim benefit, but then does not want to claim benefit, wants to pay tax, then let him pay tax. 115 TD will not come in the way. The second situation, you were registered, but you did not apply for re-registration after the expiry of that period, then also 115 TD is not applicable. I do not know whether this latter situation is a lapse. Whether this latter situation is a legislative miss or omission, that I do not know. But then the fact of the matter is, I remember last year when we were discussing about the budget with the CBDT officials who were responsible, I specifically brought this fact situation to the notice that there can very well be a situation. Registration was there. It was not, it went unnoticed. It was not cancelled. But then that trust and institution does not want to get itself re-registered and wants to pay tax later on with reference to the surpluses which it earns from its activities as a normal SSE. 115 TD, department cannot be heard saying, no, since you have not gone in for re-registrations, therefore kindly pay 30% tax on your accredited income. No, 115 TD as of now. Now, doesn't envisage, encompass this kind of contingency, eventuality or situation. So, friends, according to me, the scope of this decision, though is limited to 1023C, should not be applied to 11, 12 or 12AB. But then the mind of the court being influenced by the interpretations placed by the court in New Noble in respect of educational trust and institutions now cannot be ruled out. I remember in one of the latest decisions coming from Hyderabad bench of the tribunal in case of Fernandez Hospital. I mean, honorable members were persuaded, were led by the observations made by Honorable Court in respect of not for profit, and then they have applied to the hospitals. In fact, educational institutions and hospitals, though they may be rendering charitable services to the society, because of the specific meaning of charitable purpose given under section 2 clause 50. But of late, the courts do not see these activities as charitable by using the spectacle of the common parlance meaning of charitable purpose. I remember when I argued Queen's Educational Society case before Honorable Supreme Court. So you have not only to encounter the orders passed by the authorities below if they are not enough, because in my case Queen's Education High Court order was against me. So you have not only to encounter that High Court decision, but then you had to encounter the perception of the judges about the educational institutions and medical institutions. I remember I said, my lords, charitable purpose for the purpose of Income Tax Act now has to be seen strictly in section 2 clause 15, and therefore one should not be guided or misguided or led or misled by the common sense notion of charity. And I said, my lord, there was a purpose. Our Income Tax Act is used as a fiscal tool. Like employees' contributions you don't pay, Provident Fund, it is used as a fiscal tool. Otherwise, it is a matter of concern for the labor welfare legislations. But our Income Tax Act is used as a fiscal tool. If there are certain geographical locations in the country which are not developed, then Income Tax Act uses itself as a fiscal tool and provides deductions, exemptions in respect of the profits in case those industries are located in those areas. Similarly, our Income Tax Act, now since is used as a fiscal tool, was made as a tool to see that the function of education and health, which is primarily the function of the state, and since state, because of the paucity of funds, probably could not have met, and therefore the government said that we will not charge tax of 30%, that will be our contributions from the side of the state. Therefore, all these provisions were made. But these provisions were made with this thing in background, because to give education and to give health is the primary responsibility of the state. The state is required to establish high-level schools. The state is required to establish hospitals. And since paucity of funds, paucity of resources at the end of the government, at the end of the state, now probably compel the government to say, okay, we will not establish the schools, we will not establish hospitals. You in private sector, you establish the schools, you establish hospitals, and that 30% tax which we otherwise could have, we otherwise would have required from you, that is a contribution from the side of the state. But then, if such kind of a model has been taken, and not only taken but carried forward till this stage, but now to view the educational activity and educational activity and medical activity with the prism that where is the charity in these activities, now is something which defies that very concept with which these provisions of exemptions were enacted. I remember I had a very tough time to argue that matter before my Lord Justice T.S. Thakur, as he then was. He was not Chief Justice, he was the first Pune Supreme Court judge then, and by my Lord Justice Rohington Nariman. So, charity, I remember I had an occasion to argue some cricket associations case. Now, those cricket associations cases, now we must have seen Ahmedabad Development Authority, where Honorable Supreme Court has come very heavily on them. Now, even these cricket associations, state cricket associations, They were doing yeoman service in promoting the sports. But then, as I always say, the law keeps on developing, having regard to the change in factual metrics. IPL came. And in IPL, much fanfare is there. Parties are there. I mean, when there is 4 or 6, then there are fanfare even exhibited at that point of time. What are they called? So, when these informations come in the newspaper, perceptions are made that IPL whether can be said to promote sports. It promotes sports. Now, if today India has got 3 parallel teams in cricket, it's because of IPL. So it promotes the sports, but then the things associated with it. Now the questions are asked in circle, if at all it promotes. I remember at one point of time I was arguing a case of a school which was air-conditioned school. Again, this kind of a perception came, and that perception was expressed from that higher pedestal, from the court. I said, my lords, education is education. Now, it is not always envisaged that it can be said to be education only if the student sits on the tartan patti in mud room. I remember till 10th, I also used to sit on tartan patti under the chhappar in Nagarpalika schools. But then, merely because the students in the changed environment are given a conducive atmosphere to study. Now, whether that education will not remain education merely for the fact that the students are given a very cozy environment to sit. So, in the end, this is a clear manifestation. This decision is a clear manifestation of that perception which is there in the society, and very hard feelings against education and medical institute. I always say, when I read something in the newspaper that very concessional rate land has been given to these hospitals in Delhi and they are not treating the poor patients, I mean, with concessions. Therefore, we'll cancel their lease, and then these hospitals will stop running, or they will be taken over by. Whenever I read these kind of newspaper, these news items, definitely I am not saying even for a moment, I am not suggesting even for a moment that they should not extend the concessions which they have promised to give to the have-nots, but whatever facility, whatever medical facilities are given to a part of the society, even if that is also closed, then what purpose would it serve? Anyway, I'm not advocating even for a moment that they should not extend or they should not meet out the promises which they have held out while I mean taking the properties of the land on lease. But these are the larger questions. But of course, on the one hand, we speak on the purport and object. On the other hand, in the same breath, we try to see the strict interpretations of the law. So when the strict interpretation of the law in terms of the language of the statute is concerned, then we have to see the charitable purpose has been defined. Education is there. Medical relief is there. Education and medical relief has not been defined. That unless that education is given in only in such environment, that can be said to be education. No. But then on the one hand, there is a strict law, a strict letter of law. On the other hand, that perception which is made in the society, this is a very catch-20 situations, but then it is there. So, Poonia sir, I'll give quietus and rest to my deliberations. If there are questions, then I'll take them.
Sir, any time limit given for breather to the existing units for correction in the object clause?
No, they have not been given any time limit, but then sooner the better, because anything which is done after this date now has to be in conformity with the ratio decidendi of this law laid down by the Supreme Court.
Okay, thank you, sir.
In case of pending appeals, Abhishek ji कह रहे हैं, as per my opinion, since theorem is to be applied prospectively and the time awarded to adjust object clause existing position of law will be applicable, such was in American. So that was also my respectful view. Yes, any time limit given. अच्छा, KK Agarwal sir ने पूछ ही लिया. Then NKG sir. Sir, compliance of other laws applicable means the governing laws under which it is registered, like Trust Act or Society Registration Act, or it also includes companies of other laws such as EPF, ESI, municipal, local or local laws applicable to it. So compliance of any other law which is material to achieving the objects. So that is the gray area. Now, state legislations, the Charities Act, which are there, say in Maharashtra, or for that matter in Telangana.
सर राजस्थान सबसे वर्स्ट हिट है. राजस्थान में 1000 रजिस्ट्रेशन में से 900 कैंसिल हो गए इसमें. राजस्थान इसी ग्राउंड के ऊपर से नवंबर में. अक्टूबर वाले तो हो गए क्योंकि डिसीजन का पता नहीं लगा उनको. 31 अक्टूबर निकल गया. जो नवंबर में टाइम बारिंग थे और दिसंबर में टाइम बारिंग थे, more than 95% applications has been rejected in Rajasthan. वर्स्ट हिट एरिया है. इसीलिए उस दिन सिंह भी साहब परेशान थे, आपसे डिस्कस कर रहे थे.
Yes, very right, very right. अच्छा, now Surjit has asked this question: how profit motive or institution be just? Now
सर
this
थोड़ा सा
question,
मैं कुछ ये कंसाइज करके 2-3 पॉइंट है, मोर और लेस कवर हो जाएंगे अगर आप परमिट करें तो.
बताइए ना सर प्लीज.
एक तो सर, अगर कोई सोसाइटी, थोड़ा सा आउट ऑफ ट्रैक भी है क्वेश्चन, 12 AB में रजिस्टर्ड है, पुरानी रजिस्ट्रेशन चल रही है, लेकिन चूंकि अब लिमिट एनहेंस हो गई और हम उसका 1023C 3rd AD का बेनिफिट लेते हुए ITR फाइल कर रहे हैं
जी,
इज इट फाइन?
मतलब आप 12 AB में भी रजिस्टर्ड है, 1023C में रिटर्न भर रहे हैं.
हम 12 AB में रजिस्टर्ड थे पहले, क्योंकि पहले लिमिट थी वो 1 करोड़ थी. और अब हमारा रजिस्ट्रेशन कंटिन्यू चल रहा है, हमने रिन्यू भी करवा लिया.
देखो, वो तो लास्ट ईयर अमेंडमेंट आ गई है सेक्शन 11 में कि यदि आप 1023C में लेंगे तो 12 AB का रजिस्ट्रेशन ऑटोमेटिकली कैंसिल हो जाएगा.
ठीक है सर, लेकिन मैं 3rd AD में फाइल कर रहा हूं. 3rd AD इज नॉट रिक्वायर्ड टू एनी रजिस्ट्रेशन.
No, that may not be required. That may not be requiring in registration. But then those two terms which are there in 1023C6 are also there in 1023C3 IAD. That you should exist solely for education,
yes.
and you should not be for profit. So जब आपका assessment होगा, क्योंकि रिटर्न तो 139 4A 4B 4C में सबको भरनी है.
ठीक है.
जब आप रिटर्न भरेंगे, जब असेसमेंट होगा, तो उसमें देखा जाएगा कि आपके ऑब्जेक्ट लॉज में केवल एजुकेशनल से संबंधित ऑब्जेक्ट्स हैं या कुछ और भी ऑब्जेक्ट्स हैं. वहां पर ये कहेगा यू डू नॉट एग्जिस्ट सोनली फॉर एजुकेशन.
वो हटा देंगे हम अभी सुप्रीम कोर्ट का जजमेंट.
एंड नॉट फॉर प्रॉफिट बहुत ही कंजर्वेटिव तरीके से डिफाइन हुआ है यहाँ
पर. लेकिन वो तो सर नॉट फॉर प्रॉफिट तो अगर मैं उधर 12 AB में होऊंगा तो भी लगेगा.
नहीं, वो देखिए वहां अंतर है. वहां ये एक्सप्रेशन नॉट फॉर प्रॉफिट वहां नहीं है 12 AB में. ठीक है ना. और वैसे ये बड़ा आश्चर्य की बात है जब हमको एक्युमुलेट करने के लिए 1023C भी कहता है, 11-12 भी कहता है कि आप एक्युमुलेट कर सकते हो, 15% का प्रॉफिट तो आप कर ही सकते हो री इन्वेस्ट. तो ये इसको आप ये कहना कि आप प्रॉफिट नहीं हो, बिकॉज नॉट फॉर प्रॉफिट का मतलब हमेशा ये समझा जाता था, क्योंकि
सर 1 अप्रैल 1984 से पहले नॉट फॉर प्रॉफिट शब्द था इसमें 215 की डेफिनेशन में इटसेल्फ. जो 1983 के बजट से उसको रिमूव किया है उन्होंने.
नहीं, वो GPU में था. एनी अदर ऑब्जेक्ट ऑफ जनरल पब्लिक यूटिलिटी नॉट इन्वॉल्विंग द प्रॉफिट, वहां ये था. कभी एजुकेशन, मेडिकल रिलीफ और रिलीफ टू द पुअर में कभी ये एक्सप्रेशंस नहीं रहे. रादर बोर्ड ने तो 19 दिसंबर 2008 का जो सर्कुलर है उसमें उन्होंने कहा है कि यदि प्रॉफिट भी हो जाता है तो कोई ऐसी बात नहीं है। लेकिन अब 1023C के लिए पैरामीटर नॉट फॉर प्रॉफिट की वजह से और सुप्रीम कोर्ट का डिसीजन आने की वजह से वहां दिक्कत हो गई है। तो रादर मेरा तो अब ये प्रेस्क्रिप्शन होगा अपने क्लाइंट्स को कि 1023C की जगह आप 12AB में जाइएगा, वहां रजिस्ट्रेशन कराइएगा, वहां आपके पास एल्बो रूम है, आपको अपने हाथ पैर हिलाने की जगह तो मिलेगी।
ठीक है, तो सर हम उसको सरेंडर करके 12AB में रजिस्ट्रेशन करवा सकते हैं उसका
हाँ, बस एक बार ही है वो, उसके बाद दोबारा आप नहीं जा सकते।
तो पहले हम 12AB में अप्लाई कर दें और फिर इमीडिएटली एक एप्लीकेशन दे दें कि वी आर नॉट इंटरेस्टेड टू।
बिल्कुल सर, हाँ
ठीक है सर, थैंक यू। और एक सर जो पैरा नंबर 63 है, जो सोमिल ने उसको पढ़ा भी था,
पैरा नंबर
63।
अच्छा, न्यू नोबल में?
हाँ, न्यू नोबल में, जिसको मैं थोड़ा सा रीड आउट कर रहा हूँ, बुक्स ऑफ अकाउंट्स वाला। We list the statute potentially applies to newly created organizations,
yes.
institutions or trusts. It equally applies to existing institutions, societies or trusts, which may seek exemption at a later point. At the same time, this court is also of the opinion that the commissioner or the concerned authority, while considering an application for approval and the further material called for, including audited statements, यहाँ इंपॉर्टेंट है, मैं आपकी ओपिनियन चाहता हूं, should confine the inquiry ordinarily to the nature of income earned and whether it is for education, and लगाया है वर्ड, whether it is for education or education related objects of the society or trust. If the surplus or profit are generated in the hands of assessee applicant in the imparting of education or related activities, disproportionate weight ought not to be given to surpluses or profits provided they are incidental. At the stage of
ये दोनों तरह की बातें कह दी है उन्होंने।
At the stage of registration or approval, therefore focus is on the activity and not the proportion of income. इसको थोड़ा सा हिंदी में एक्सप्लेन करें सर कि हमें क्या ध्यान रखना है फ्यूचर में।
देखो, एक्चुअली क्या होता था, जब नए ट्रस्ट सोसाइटीज अप्रूवल के लिए अप्लाई करते थे और कई बार इस ग्राउंड पे रिजेक्ट कर देते थे उन अप्रूवल को, इवन रजिस्ट्रेशन 12AA को भी इस ग्राउंड पे रिजेक्ट कर दिया करते थे, आपकी कोई एक्टिविटी तो है नहीं। तो उस वक्त ये बिकॉज 12AA में या 1023C में ये तो लिखा नहीं है कि पहले आप एक्टिविटी करेंगे तब आपको रजिस्ट्रेशन मिलेगा, अप्रूवल मिलेगी। तो उस सिचुएशन को एनविसेज करते हुए इन्होंने ये कहा है कि अप्रूवल नए वाले ऑर्गेनाइजेशंस भी अप्लाई करते हैं और पुराने वाले भी करते हैं। नए वालों के लिए नेचुरली बैलेंस शीट प्रॉफिट लॉस अकाउंट नहीं होगा, लेकिन यदि 2-3 साल बाद जब आप कर रहे हैं तो बैलेंस शीट प्रॉफिट लॉस अकाउंट होगा, वो मांग सकता है आपसे। लेकिन मांगने के बाद आपकी एक्टिविटीज देखी जाएंगी जो पहले भी होता था, और आपके इंसिडेंटल आपके सरप्लसेस भी देखे जाएंगे। लेकिन इस स्टेज पे यदि कोई डिस्प्रपोर्शनेट सरप्लसेस हैं जो ये प्रूव करते हैं कि आप प्रॉफिट मोटिव के लिए कर रहे हैं तो ही ध्यान रखना, वरना सरप्लसेस हैं तो उसको इस स्टेज पे देखने की कोई जरूरत नहीं है।
ठीक है, थोड़ा सा पॉजिटिव है ये,
मतलब पॉजिटिव है। इनफैक्ट क्या है, वो सुरजीत मेरा दोस्त है, उसने मुझसे एक क्वेश्चन पूछा है कि नॉट फॉर प्रॉफिट में उसका कोई क्राइटेरिया क्या है। देखिए, क्राइटेरिया उसका कोई सिंगल टेस्ट नहीं है। जब सारी एक्टिविटीज ईयर आफ्टर ईयर देखने के बाद ये कि सरप्लस आफ्टर सरप्लस हो रहा है और उनको लेके फिक्स डिपॉजिट्स में हम जमा कराते चले जा रहे हैं, ठीक है ना, तो दैट मे बी वन ऑफ द इंडिकेटर्स टू से कि यू आर नॉट एग्जिस्टिंग, यू आर एग्जिस्टिंग नॉट फॉर प्रॉफिट। बट देन इफ, हालांकि इसमें पूनिया साहब का जो क्वेश्चन है और जो हर एक के मन में आता है,
क्वींस एजुकेशन सोसाइटी में तो 6-7 लाख रुपए ही थे बेचारों के और 50-60 लाख रुपए ही रिसिप्ट थी। आप ही ने आर्ग्यू किया था, उसको ओवररूल कर दिया, तो क्या उसकी बैलेंस शीट से हम डिराइव कर सकते हैं कि
क्वींस एजुकेशनल में रादर मैंने ये कहा था, मैंने कहा माय लॉर्ड, पाई टू पाई मैचिंग नंबर एक बात तो हो कैसे सकती है। दूसरा, यदि मैंने सरप्लस अर्न नहीं किया तो मैं एक्सपेंशन कैसे करूंगा, मैं ग्रोथ कैसे करूंगा। भाई मुझे और रूम्स बनवाने हैं, और क्लासेस ऐड करनी है, फैसिलिटीज लानी है, तो मैं सरप्लसेस जनरेट नहीं करूंगा, तो मैं आप क्या ये सेक्शंस को ग्रोथ और एक्सपेंशन के एंटीथेसिस है क्या ये? अब ये जो डिसीजन इन्होंने दिया, इंसिडेंटल सरप्लस हो सकता है, लेकिन क्या है कि कुछ ऑर्गेनाइजेशंस, मुझे याद है मैंने कुछ केसेस किए जहां सरप्लस ईयर आफ्टर ईयर हो रहा है, 10-10 साल तक वो एफडी में जमा है, कोई एक्सपेंशन कहीं यूज नहीं हो रहा। तो इट इज द क्यूमुलेटिव एप्रिसिएशन ऑफ ऑल द फैक्ट्स पुट टुगेदर ओवर ए लार्जर पीरियड ऑफ टाइम दैट विल डिटरमिन कि whether you exist for profit or you exist not for profit. So no single test is conclusive. It is the cumulative impact of several tests, that too over a somewhat longer period, that will determine your character.
अच्छा, एक सर ठीक है, ये थोड़ा सा समझ में आ गया कि हमको इंटायरिटी ऑफ द फैक्ट्स देखनी है।
अब
एक बार कहीं सरप्लस हो गया,
पूनिया साहब, मैं आपको ऐसे बहुत सारी सिचुएशन है कि ये आपका इन्वेस्टमेंट है या बिजनेस, बहुत सारे फैक्टर्स होते हैं, कोई सिंगल टेस्ट नहीं है इसके लिए कंक्लूसिव।
ठीक बात है सर।
तो ये बॉर्डर लाइन चीजें जो होती हैं, ये डिटरमिन होती है क्यूमुलेटिव इम्पैक्ट से।
गौतम जी, आपका जो क्वेश्चन है ये राजस्थान से रिलेटेड है। राकेश जी के पास अभी एक्ट नहीं है और इसलिए उसका इंटरप्रिटेशन इस तरह से हो नहीं पाएगा।
मैंने डेफिनेशन सर पोस्ट की है, अगर रिलेवेंट समझे तो सर।
हाँ, लेकिन पूरा एक्ट की पर्सपेक्टिव के बगैर इतनी स्मॉलर डेफिनेशन को एक्सप्लेन करना बड़ा मुश्किल होगा, और फिर भी मैं राकेश जी से रिक्वेस्ट करूंगा। उससे पहले सर एक पैरा नंबर 73 है न्यू नोबेल का।
अच्छा,
जो इन्होंने सोमिल जी ने भी पढ़ा था कि अगर कोई एजुकेशनल इंस्टीट्यूशन अपना सेमिनार हॉल किराए पर देता है और उसमें खुद के स्टूडेंट्स नहीं पढ़ते हैं, तो वो न तो इंसिडेंटल एक्टिविटी है, वो न एजुकेशनल एक्टिविटी है, दैट विल बी ट्रीटेड एज अदर इनकम।
इतना ही कहकर छोड़ दिया है।
और अदर इनकम मेरे को अलाउ ही नहीं है, क्योंकि वो कहते हैं सोनली फॉर एजुकेशन में आप एजुकेशन के अलावा कोई काम नहीं कर सकते, सिर्फ इंसिडेंटली कर सकते हो।
ये बड़ा आपका इंपॉर्टेंट क्वेश्चन है कि यदि सरप्लस, मेरा ऑडिटोरियम है, मेरे लिए तो साल में 10 दिन इस्तेमाल होता है, और इफ आई कैन मेक इट वर्केबल एंड एक इकोनॉमिक प्रपोजिशन, जो इनकम आएगी वो मैं एजुकेशनल पर्पस के लिए इस्तेमाल करता हूं, तो उसको क्यों रोका जाए? मतलब ये सारे आपके जो कंसर्न है बिल्कुल जायज है, लेकिन इस डिसीजन के हिसाब से तो आपने, जैसे सोमिल ने कहा कि उसको यदि किसी और को किराए पे दे दिया, अब सपोज कोई वहां का डीसी है, वो कहता है भाई चीफ मिनिस्टर की मीटिंग होनी है और ये लोग 20,000 रुपए देंगे हम, तो आप मना कर दोगे क्या? मना कर पाओगे क्या? दोगे तो बात की बात है, मना कर पाओगे क्या? नाउ दैट विल कम। बड़ा प्रैक्टिकल ये एग्जांपल है। तो अब इस तरह का इंटरप्रिटेशन देना कहा था कि उचित है, लेकिन अब क्या करें।
इवन जयपुर में भी है सर, आपने भी सेशन लिए होंगे, विद्याश्रम स्कूल में सेशन लिया होगा और महावीर स्कूल में सेशन लिए होंगे। बिरला ऑडिटोरियम तो चलो एक चैरिटेबल ट्रस्ट का है, और साथ में सर इन दोनों जजमेंट्स को हम न्यू नोबेल और अहमदाबाद डेवलपमेंट अथॉरिटी को दोनों को पढ़ते हैं ना, क्योंकि एक ही दिन के जजमेंट हैं, सेम बेंच है, तो लगता है कि उन्होंने
नहीं, दोनों को हम साथ इसलिए नहीं पढ़ सकते क्योंकि वहां पर 215 का जो प्रोवाइजो था और जो रेजिडरी क्लॉज था, केवल वही इंटरप्रिटेशन के लिए था। एनी अदर ऑब्जेक्ट ऑफ जनरल पब्लिक यूटिलिटी का इंटरप्रिटेशन, और उसके बाद जो प्रोवाइजो है उसका इंटरप्रिटेशन, और वो प्रोवाइजो बाकी हेड्स पे नहीं लगता है, एजुकेशन पे नहीं लगता, मेडिकल रिलीफ पे नहीं लगता, इसलिए इन दोनों को हमको साथ पढ़ने से कोई पर्पस सर्व नहीं होगा।
ठीक है सर, ठीक
है ना सर?
ये हमारे गौतम जी, हमारे राजस्थान पब्लिक चैरिटेबल ट्रस्ट एक्ट है, उससे रिलेटेड उन्होंने सेक्शंस लिखी है पब्लिक ट्रस्ट।
आप मुझे भेज देना और मैं अब रिक्वेस्ट करूंगा इसको खत्म किया जाए, मैंने आगे निकलना है, कोई सोशल फंक्शन में जाना है।
ठीक है,
ठीक है जी।
ठीक है सर, आपका बहुत बहुत धन्यवाद, और उससे ज्यादा ऑडियंस का धन्यवाद। ऑडियंस है तभी, आजकल श्रोता सबसे मुश्किल काम है, जो हमको इतने श्रोता मिले हुए हैं और यूट्यूब पर भी है। और मैं एक थोड़ी सी मेरी भी एक इंफॉर्मेशन दे देता हूं। चैरिटेबल ट्रस्ट के रजिस्ट्रेशन के ऊपर मेरी एक बुक आ रही है, हिंदी में आ रही है, और हिंदी भी जो राकेश जी ने शब्द बोला इंग्लिश में आ रही है, और FAQ के फॉर्मेट में आ रही है, और मोस्ट प्रोबेबली कल 14 जनवरी को बीकानेर में वहाँ ऑनरेबल मिनिस्टर अर्जुन राम जी मेघवाल और हमारे इंस्टीट्यूट के प्रेसिडेंट कल बीकानेर में हैं, रीजनल कॉन्फ्रेंस को इनोग्रेट कर रहे हैं। वहां पर वो लॉन्च हो जाएगी, अभी मेरे हाथ में नहीं आई है, अभी पब्लिशर के यहाँ से उसकी फर्स्ट कॉपी मेरे पास आने वाली है। और सोमिल को और राकेश जी को भी बहुत बहुत धन्यवाद, इन्होंने बहुत वाइब्रेंट ढंग से और सारे जो प्रैक्टिकल एस्पेक्ट्स हैं वो डिस्कस किए हैं इस केस में। और अभी फ्यूचर में दोबारा हो सकता है राकेश जी से बात करेंगे, अहमदाबाद डेवलपमेंट अथॉरिटी के ऊपर दूसरा सेशन करवा लेंगे। तो बाकी जो क्वेश्चंस बचे हुए हैं चैरिटेबल इंस्टीट्यूशन से रिलेटेड, वो जब अहमदाबाद डेवलपमेंट अथॉरिटी पर डिस्कशन होगा तो उसमें कवर हो जाएंगे।
आप मुझे एक काम करिएगा पुनिया साहब, जो क्वेश्चंस आए हुए हैं वो जरा मुझे आप इनको कॉपी कैसे होता है मुझे आता नहीं, तो वो लेके आप मुझे भेज दीजिएगा।
अरे आता मुझे भी नहीं, अगर सोमिल कर सकता हो तो, क्योंकि मेरे पास भी सेक्रेटरियल असिस्टेंस है नहीं, मेरे जो जूनियर्स है ना वो सारे भाग गए, क्योंकि जयपुर में संक्रांति का त्योहार है, बहुत बड़ा त्योहार होता है, होली दिवाली से भी बड़ा माना जाता है। तो
हो सकता है कि ये जो क्वेश्चंस आए हुए हैं
कॉपी कोई भी कर सकता है, अगर और कोई ऑडियंस में से इनको कॉपी कर सकता हो तो प्लीज।
एक्सपोर्ट करने की कोशिश कर रहा हूं पर मुझे ऑप्शंस नहीं दिख रहे हैं यहाँ पर, प्रॉब्ली मैं होस्ट
कोई
नहीं हूं इसलिए
कॉपी
हो
का
सकता
बहुत
है।
सिंपल सा सिस्टम होता है जिसको आता है।
एक काम करते हैं, मेरा टेलीफोन नंबर दे दो, व्हाट्सएप कर देंगे मुझे।
ठीक है, इसमें
98104 20515 98104 20515। पुनिया साहब।
हाँ सर,
आपने लिख लिया, आप भी सर्कुलेट कर दीजिएगा प्लीज।
मेरे पास तो है आपका नंबर और ऑडियंस
आपके पास तो है, आप अपने उसमें सर्किल में कर दीजिएगा ना।
हाँ बिल्कुल बिल्कुल, मैं सर्कुलेट कर दूंगा।
हाँ ठीक है सर।
ठीक है ठीक है,
ओके सर, नमस्कार जी, सभी को नमस्कार, सभी को नमस्कार।
थैंक यू।
नमस्कार।